This is potentially criminal who I've been on stream with on Flashcast multiple times. Great all around dude and a lawyer. Great channel. Check him out. And he covered the latest filing that got sent to the courts today. And it was a filing that was mutually agreed upon between Alyssa's lawyers and Ron Coleman, my lawyer. And he discusses it here, which I was going to talk about tonight, but I'm like, well, I'll talk about it with an actual lawyer by listening to him and then talking to it, because I think that would make a lot more sense.
This action on the 28th, this guy's on court listener, so you could find all of this.
Can you hear him okay?
So this action on the 28th is the letter we just read. March 3rd, it says an order denying the letter motion for a pre-motion conference. The court directs the parties to confer and file a proposed briefing schedule for defendant's motion to dismiss and proposed amended complaint on or before March 14th.
Vito says low
by Judge Brody.
I can turn up a little bit.
Judge Brody, putting the bro in Brody. Well,
a little higher.
I saw they were talking about the individual rules here, chat, and this is something where, I got the.
All right, that's as high as I can make it.
What then got filed is something today.
So this is brand new.
Press, and this is something
This is what got filed today, and this is the joint filing.
You're probably going to look at, and I want to address it. This is a letter from, once again, Alyssa's attorneys, and this is where this is something that's been worked out. It's a joint letter, but somebody has to file it. And typically the plaintiff is the one in charge of this, so it's up to them to get it going. Let's see. Oh, people are talking. So, my firm of co-counsel represents plaintiffs in the above case. Okay, I mean, did you really have to, we represent plaintiff? Okay. Per the March 3rd minute order.
First I heard him say that, I was like, well, they probably just want to be clear with the judge. But I think he's rolling his eyes at that because he's like, yeah, the fucking header on the page tells me that. You don't need to start it with telling us that. We know that's who you are.
I write jointly with counsel for a defendant, meaning Ron Coleman agreed with this, to propose a briefing schedule for the defendant's motion to dismiss. Oh. Am I muted, chat?
He talks for like 10 seconds about being muted here.
She's like, you're muted. And this is what you have to do. So, Russell Greer, if you're out there, this is how adults handle legal matters. They meet and confer, and they provide the court with updates.
Which I will say, shout out to Ron Coleman. He's a lot more level-headed with this stuff than I would be with working with them, where I'm like, fuck them. And he's like, now. I love Ron. He's great.
So they say the parties have agreed on following. By March 28th, the defendant's motion to dismiss will be served on the plaintiff. By April 18th, the amendment will be filed or the opposition to be served on Ron and JT. And then by May 9th, JT's reply will be served on Alyssa or the response to amended complaint. Because remember, they could do either or to be filed. So this is the timeline we're looking at right now. This is how far we're going out. We're going out into, there's one.
Yeah, this is the timeline proposed, given to Judge Brody today, meaning that just to get the initial stuff back and forth, we're getting into May at this point. This is months away from right now. Just to get to the point of the judge looking at the stuff again. Which probably speaks to why Alyssa was so concerned about money and finances, because this is how court cases get very expensive. It's not something that just happens overnight and wham, bam, thank you, ma'am. Thank you for the money. Some people might be used to that. But as far as how court works, it's a little bit more long-term than that.
Date in March, there's one date in April, and there's one date in May. This is really getting pushed out there, guys. But
this guy's voice is annoying as fuck. I love this guy's voice. It sounds like a cartoon character. I love it.
This is what parties do. This is actually acceptable. This is good. They're working things out. Now, from here, it says, because the court follows a bundle rule. It says individual practice, section 3D. it says on May 10th, the parties
He
proposed
sounds like he's a Family
filing the
Guy.
full
Exactly.
bundle in the event the motion is fully briefed, and otherwise jointly propose a briefing schedule if plaintiff amends and the defendant still decides to file a motion to dismiss. Now, this is actually very important. This is we're going to talk about what the bundle rule is, because this is, like I said, chat, this is how every court does whatever they want. And you can actually go online and Google the individual rules for Margot K. Brody for the Eastern District of New York, and we're going to look at these. You can do these for all the judges there. So they're going to follow a bundle rule, but they also said if there's an amendment, if plaintiff amends and Ron still decides to file a motion and dismiss, they're trying to figure out what to do and like how they'll handle it. And they're saying, judge, this is what we're going to do, and the judge will probably sign off on it. And they say, as always, parties thank the court for its time and consideration. Respectfully submitted, J. Remy Green. Now, here's the thing. You might say, well, why isn't Ron Coleman signing this? He doesn't have to. Because up here, she has vouched that Ron Coleman has agreed to this. Because let's say Ron Coleman's like, whoa, 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 whoa. That's not what happened. That would be a big deal. But this is how this works. You don't have to sign joint orders like that.
I'm learning quite a bit about how the court systems work.
So
here.
What are these individual rules, just so we can see them? And you know what? Hold on, chat. We're going to get the super chats real quick. We got to get these done.
I sent him a super while he's doing
He
this.
says,
I don't know.
Smile. Remember, chat. Free. I appreciate it.
See, that was me.
So
wait, what's he say?
Smash JT for $19.99 for the super sticker. Thank you, JT. I appreciate it.
This guy's great.
So anything that's hot over. Plus self-defense.
I saw he was streaming about my suit, and I was like, oh, I love this guy, and he's talking about me. I definitely want to donate to him.
Thank you.
It's a good dude.
You're like Obliger on you. Which one of you? White helmet alpha. We'll find out. Well, there are two. Them. That appreciate it, Rob. Watch. Christy the Great. That's the actual rules, because you saw they were quoting this stuff. And knowing the local rules for what court you're in.
This is really potentially criminal.
Important. So this is
He's
Judge
an actual
Margot
lawyer.
Brody's rules if you want to be in front of her. And is it, can you say like, oh, shucks, I'm a big old tard if you don't know the local rules? Can you get away with this? I mean, yes, maybe.
He's very based.
What it does, though, is if you show up into a court and you already know your local rules, you look good in front of the judge, especially you ain't never been there before. Judge is going to be impressed. You took the time to read the fucking rules. So,
what he's saying right now is
all the information.
And this is again another thing that I'm learning about how courts work. Every single court, every single judge has their own local rules, which are basic like expectations to be followed. And those can vary widely from judge to judge. And he just said, you don't need to know them. But if you show up and you didn't research them, it's not a great look. The judge typically frowns upon that. But if you show up and you understand and you do everything that the judge has on their rules with what their expectations are, it makes you look better.
To get a hold of her, this is her case manager. This is going to be a very critical person. This is like a bailiff or a judicial assistant in that regard. This person's in charge of running the docket. So this is somebody you never want to fuck with. Never want to fuck with one. So, unless otherwise ordered by the court in a specific case, matters shall be conducted in the courts with the following rules for her. Now, I'm assuming a lot of the judges have similar ones. It kind of looked like it. So they talk about like electronic case filing, how you file stuff under seal, review of ECF, that's electronic filing submissions. It gets to courtesy copies. Now, what's a courtesy copy? This is actually something not every judge is big on, but I always ask because you kind of need to know. You kind of need to know if a judge wants courtesy copies because it's kind of a big deal. A courtesy copy allows you, and I was in the wrong PDF here. A courtesy copy is when you provide the judge directly with a copy. So, for example, I'll file a motion to suppress. It's going to take a couple of days. Clerk's going to get it. It'll get into the file, and eventually that'll make its way to the judge.
The judge just wants it ahead of time.
Instead, you take an extra one that's time-stamped. You get one, they stamp it, And if it's electronic filing, I can email it to his judicial assistant. It's up to them. It's their preference. But I take that one and I walk it down the hallway to the court and go, hey, you're the bailiff or the judicial assistant, whoever. Here's a courtesy copy of a motion I just filed and served on the prosecutor.
Mm.
And then the court has it, and it's just for courtesy. So courtesy copies are a big deal. Courtesy copies are a big deal. Hi, Hella. How you doing? Good to see you, by the way. You can't talk much. You're fighting a cyclone. Or no, that's not good. It's probably also fighting the Chinese Navy out there. So we move on to requests for adjournments or enlargement of time.
All right, here
that
we
just
go.
means continuances. Now we move on to the 3 here. Motions. They have the pre-motion conference request. And they talk about what else you could do here. Memorandum of law, briefing schedules, filing of motion papers. And they talk about, as a courtesy of the court requests that parties refrain from filing motion papers until the motion's been fully briefed. So what does that mean? You do it all at once. You do it all at once. And I think there is
all this stuff is so over my head. I'm like, what? It's a different world. Lawyer speak is like,
anyways, this is where you get to it. You file everything at once. This is that bundle.
Is the bundle that he was talking about on the original.
So you guys have never seen that before. That's what the bundle is. That's what the bundle is, chat. So you wait until everything is done. Also, real quick, when you're seeing this here, so if the parties elect to file their motion only once it's fully briefed, the notice of motion and all supporting
papers really is Shakespeare in court.
The cover letter setting forth what's being served. On the day the motion is fully briefed, each party shall electronically file its moving papers. In addition, the moving party, meaning in this case, it'll be Ron saying we're moving to dismiss, shall furnish chambers with the full set of courtesy copies of the motion papers together with a letter specifying each document in the package. Courtesy copies should only comply with Rule 1D of these rules. A copy of the cover letter shall be sent to the assigned magistrate judge and opposing counsel and shall also be electronically filed. So we're going to get some of this.
Damn, there's a lot of work every time you do anything.
This is very elaborate. You don't do this in state court. This is federal court. Federal court is very hoity-toity. It's like SpongeBob, like pinky up, chat, pinky up, higher, SpongeBob.
Pinky out.
That's where we're at here.
That was a great SpongeBob episode. I love that he knows that one.
So this is important. This is important here. So that's why they're mentioning it. And I just thought that was, aside from the fact I think their motion's dog shit, I thought it was important to address that because what does all that mean? If you guys have never seen it before, that's what that stuff means. And I thought it's critical for us to talk about it. So that is that's a thing. MK 1400. That's a lot of. Is it like MK Ultra? Is that the MK Ultra that they? It's like the T1000 going. I don't know
if he talks about it anymore. That's basically it.
By the flares. You just want to know.
I think that was the end of him talking about that today's filing.
For tonight's
but today's filing was basically
he can't do that.
What he was talking about here.
You do.
Let me bring it back to it.
Not going to let you just.
Here it is.
And you can actually go online and Google the.
So this is publicly available. This is online for everyone. I had multiple people send this to me today, and they're like, "Bro, did you hear about this?" And I was like, "No, I didn't." And I mentioned it to Ron. He's like, "Oh yeah, no, I'll send that to you." It's just a agreement of both sides of what the times and dates are for what the plan is. It's nothing crazy. I think the biggest takeaway from this is the time frame that we now understand is going to at least nearly mid-May, just to get this back in front of the judge to decide on what to do next with it. Again, that's giving the judge additional time and giving Alyssa's side additional time to try to find something and come up with something to sue me for, because their original complaint at this point looks to be garbage. I could be wrong about that, but from everything that I'm understanding, that was their original complaint. We pushed for a dismissal, and they're coming back with a whoa, don't dismiss it, Judge. We actually have more information we want to talk about. That's the way that I'm gathering the info right now. At least that's how I understand it. And now the next step is we have defendant's motion to dismiss to be served on plaintiff. So on 3/28/2025, we have a due date for that to send a motion to dismiss. And then on 4/18, they have a due date, plaintiff's amendment to be filed or opposition to be served on the defendant. So what Alyssa was really frustrated with today was she's like, I just want your motion to dismiss right now. Just give it to us now and we can amend. Don't make us wait for it. Why are we doing all these extra steps? That costs more money and takes more time. And you know what I said to her? In my own little way? You goddamn right it does. Ask me if I care if it takes more time and costs more money. I don't care. This is not my problem, Alyssa. This is your lawsuit you've brought against me. I'm not here for your charity. I'm not here to help you out with it. Like I don't think you understand where we're at right now, but do not expect assistance from me anywhere along the way here. That's not how this is going to work. So whenever there comes a point in time when you're like, oh, we could really use them to really work with us here on this situation, just assume I will do the exact opposite. What is going to make it more challenging for you, I will go that direction because you have invaded my privacy, put my family in danger, threatened me, doxed my family, my kids, my wife, my life, made us live in fear while you quietly just redacted your information because of, get this, your own personal safety concerns. That's rich. I can't wait for a judge to hear about that one and see what they think and who they're dealing with here. Do you really think that anyone logical is going to look at this situation, look at you and be like, oh yeah, that person clearly has a good head on their shoulders. I bet what they're saying is backed up with facts. Ah, man, good times. Anyways, that was basically all I had with that one.